You know, when signing up for these credit cards, you often agree to give up your right to go to court. Instead, you agree to something called arbitration. Well, last week, we told you about a lawsuit against a major credit card arbitration company, questioning the fairness of the process.
And our consumer lawyer, Eric Seidel, joins us now with news of the settlement that could have a major impact on all consumers. What's going on, Eric?
Well, Kelly, this agreement is being hailed as a victory for consumers. The National Arbitration Forum will no longer be allowed to settle disputes between credit cards and consumers. Now, attorneys who represent credit card customers tell me they know their customers will be getting their day in court.
Many of us don't give a second thought to our credit cards unless we're using them or paying them. But credit card companies think a lot about how they'll settle any disputes with you, putting arbitration in all their contracts.
There's no day in court, so to speak. It's just based on the documents, and consumers tend to lose.
Not only that, but if you look at your credit card contract, it likely requires arbitration be done by the National Arbitration Forum, or NAF. Last week, Minnesota's Attorney General sued them for fraud and deceptive trade practices.
This company has extensive ties to the debt collection industry, yet tells the public that it will independently resolve hundreds of thousands of claims. This is not an independent company. It needs to stop deceiving the public by saying that it is.
To settle the case, NAF, the largest debt collection arbitrator in the country, has agreed to get out of the business. So what does that mean for Bay Area consumers?
In most cases, the arbitration provision could become unenforceable. So the rest of the contract may stay in force, but taking it to arbitration may be moot.
Credit law attorney Rinki Parwani represents hundreds of borrowers in these cases.
Most cases pending in arbitration, what I've seen so far, have been stayed already prior to the settlement, or they are being dismissed.
That's because going to court makes it more expensive for credit card companies to pursue their claim.
So if you've got a small unsecured debt, the likelihood, unless they take it to small claims where it's inexpensive, that the credit card company is going to pursue it and hire an attorney to go to court for them is pretty nil.
Meanwhile, the Attorney General from Minnesota, who started the whole thing, will be in Washington tomorrow, talking to lawmakers about banning mandatory arbitration clauses in consumer contracts altogether.
As for consumers, this isn't a total get-out-of-jail-free card. Some credit card companies will still take you to court or try to enforce arbitration with another company. I do know some attorneys are hoping to invalidate previous decisions made by NAF arbitrators. For its part, the NAF released a statement saying that it's voluntarily pulling out of the arbitration business due to the legal costs of lawsuits against them like this one in Minnesota, and they say the uncertainty surrounding the arbitration business. Kelly and John?